2025 Provincial Court of Badajoz, First Section. This morning, at the last minute, a matter was raised by counsel for Manos Limpias, requesting that it be read aloud at this hearing. The recording of the statement of the accused, Mr. David Sánchez Pérez Castellón, should be played at this hearing, based on the provisions of Article 714 of the Criminal Procedure Act. The defense was notified and they objected, arguing that this article is not applicable because it refers to witnesses, among other considerations. The court will resolve this incident as well as the others that were raised regarding the possibilities for the private prosecutors to present in the written final submissions. All right, let's go step by step. This matter has legal significance. It's complex, but it will be resolved. It rules in favor of the argument advanced by counsel for Manos Limpias. Exactly. Look, a very recent Supreme Court ruling, April 30, 2025, confirmed by another on April 22, 2026, in a case identical to this one, identical. I'm going to read some paragraphs verbatim. I only have a few, of course, because it's very long. The Court of First Instance, says the Supreme Court, with Vicente Magro Cervez as the reporting judge, issued the ruling unanimously. The the Court of First Instance, that is, in this case, us, can give precedence to the evidence presented during the investigation phase over that presented during the trial. Cases of discrepancies between the two, as the attorney has pointed out, as long as it was carried out judicially with the proper guarantees and was subject to effective adversarial challenge at trial, as happened in this case, because that statement was made with the proper guarantees. Another judgment dated December 20th, 2006 is cited. 2. When a defendant or a witness, here the judgment says when a defendant or a witness. Therefore, in two situations they testify at trial. Previously they did this in another phase, either before the police or judicial authority. As this is the case of the defendant, the court handling the case, and that's what the judgment says, that is us. It has the authority to grant credibility to one or another of such statements. What the Supreme Court says is very clear. In whole or in part, as another expression of the principles of immediacy and joint assessment of the evidence, so that it can write in its judgment the proven facts, taking information from one or another of such statements according to the credibility they deserve based on its own judgment. Article 741 of the Criminal Procedure Act, as long as a series of formal requirements are met, among them that the statements made by the accused during the investigation phase are read so that they can be used in the judgment. This is the case that counsel is presenting. Reading statements made by the accused during the investigation. In this case, the reading is watching the recording at the time marks you mentioned. All right. And based on this reflection, which is fundamental, the court could consider those preliminary statements. Thank you. Once fulfilled, to summarize, you assume the sentence. I'm telling you, it's very instructive, very clear. The judgment of April 30th, 2025, later ratified by another judgment on April 22nd, 2026, just the day before yesterday. After these procedures are done, the prosecution may argue in its report that the preliminary statements should be considered due to the defendant's silence, but only if the formalities are met. All right. Essentially, that's it, and therefore the request is granted. Next, before addressing other matters, we will proceed to watch the statement of Mr. Sánchez Pérez de Castellón, which he gave during the preliminary phase with all the necessary guarantees. Concerning the statute of limitations raised by the attorney, the court finds the following. With respect to the statute of limitations for the offense in Group A, which is attributed to the defendant Mr. David Sánchez, even though this statute of limitations would extinguish any potential criminal liability he might face for the crime of accepting an illegal appointment, the court considers that nothing prevents it. that, if applicable, the statements made by him by Mr. Sánchez during the investigative phase could be taken into account after listening to them in this proceeding. And on the third issue that was raised, now once I resolve the third issue, we will proceed to view those statements, the statement in question. The third issue is resolved. Yes, please wait. Yes, but the order is no longer there. It won't be the same. It will be the same. Yes? Not the same. How many papers? Thank you. Here it is, yes. In the order that this court issued, I'm going to remind you of the operative part, yes. Order dated January 12, 2026 by this same chamber. Reporting Judge, Mr. Emilio Francisco Solano Molera. Operative part, we order that the private prosecuting parties joined in this case be separated, allowing them to exercise their punitive and compensatory claims under independent legal counsel and procedural representation, separate from the others. Therefore, they may exercise their punitive and compensatory claims, which on the other hand is logical. Therefore, what counsel raised with me this morning is possible. Regarding equality of arms afterwards, well, I think we have achieved a reasonable amount of time. Counsel, so that from this morning until now, you have been able to, we can't have more time, because what is fundamental is to leave a reasonable period so that the final arguments can be made after a 2 or 3 day break, so that the parties can study everything. Therefore, it is possible, and the floor will be given to the parties for the specific procedure. Conclusions. Indeed. We are going to play back the statement. Well, sir, I know you are going to disagree logically, and that's legitimate, besides. But you will all do it in your case of appeal. And if not, it's necessary to record the objection, because we're not here in a preliminary phase. En fase de cuestiones previas. You won't lose the procedural opportunity. As I'm saying, and it's being recorded, there's no issue. All right, let's see. The statement of Mr. David Sánchez Pérez Castejón, which he gave during the investigation phase before the investigating magistrate, will now be read. Thank you, thank you. Can you pause for a moment? Stop, stop. Stop this. Yes, sir. To raise this point, I'm not saying it right. Thank you. Yes, yes, it sounds good. It sounds good. One question, one question. Is it an hour and 20 minutes long? Thank you.
Counsel would like to speak briefly, excuse me.
Yes, he has to clarify. He already did it. Yes, yes.
Well, yes, we had clarified it more or less approximately because the exact minute and second is very complicated. I mean, I do it with a program that transcribes it and all, so it's complicated.
Say the minutes.
Okay, approximately, so I'm going to start a little earlier so nothing gets lost. It was, well, from 5 minutes and 30 seconds to 7 minutes. I'm adding a bit more time to the yes, sir, all right?
Yes, yes, you do it as you see fit.
Okay, well, yes, sorry, from 47 or 5:30 to 8:48.
To 8:50.
Or to 8:50, perfect. From minute 10.
Let's go step by step. Counsel will say it first, then we'll return to it.
Yes, from minute 10 to minute 11.
Yes.
From minute 14, 15, maybe 14, just to be sure. From minute 14 to minute 17.
Yes.
From minute 18 to minute 22:30.
Yes.
From minute 28:30 to minute 36. From minute 43 to minute 45. And from minute 46 to minute 53:30.
53:30.
Maybe I narrowed down something I shouldn't have.
These references are enough. Let's see. Well, that's how we're going to do it. I'll let you know.
Nuria. We called the IT guy in case you want him to answer you.
I'll answer you through the computer.
Okay, the IT guy is coming. Is he on his way?
Yes. We also requested this because the gentleman testified twice during the investigative phase, and he gave two statements. I understand this is the first one because there are two different statements. And then a second statement, which we also requested this morning to be limited. I'm looking at it here. The second statement is from April 25th, 2025. One moment.
What day is this one from?
This first one is from January 9th, 2025.
January 9th, 2025. Now you say from the 20 what?
April, from April 25th.
Also?
From 2025, the second one.
You have the timestamps marked there?
Here I have them marked out. First of all, it was about the topic mainly about Airbnb rentals. That goes from minute 2 to minute 3.5.
From minute 24:33 to minute 26:13.
From 24:30 to 26.
To 26:30?
26:30. Yes, yes.
That's it. Perfect.
Let's see if the IT guy shows up. Thanks a lot. Thank you very much. Thanks to the good professionals we have in this court, things work, and that's true. All right.
Well, during that time, I was finishing a master's degree in my, yes.
Hold on a moment. Look. Counsel, I have the timestamps noted down here. In the first statement, there it is. I think... Let's go step by step. Do you all understand it well there? From 5:30 to 25:20.
Right around there.
It's the first one. Let's get started.
The attorney is here, and since early June, he likely knew everything, but I wanted you to hear directly from me what we're discussing.
Well, I have also read your rulings carefully, so I'm doing great. Also, with the assistance of my attorney. Very well. I'm fully aware of how the process is developing.
Tell me, first of all, David, where were you working between September and October of 2016? Do you remember?
September, well, during that time, I was finishing a master's degree in Milan.
Yes.
Well, as a conductor, I had various engagements. That year, I also had a premiere, a commission for one of my works, which was premiered by the National Orchestra of the Capitole de Toulouse in France. And well, but mainly in September.
Specifically, do you remember where you were in September 2016?
Well, probably.
Your Honor, may I intervene? It's me. Let's see. I'm sorry to repeat what I said this morning. I believe that acknowledges the court's decision, but that's not the point. I believe that this morning you heard that Mr. Sánchez has only testified regarding the change in the title of the post and the creation of Mr. Carrero's position. But the only retroactive action that has taken place has been the one related to the offices. I mention this because, for example, this detail about him doing a master's degree in Milan, it's impossible for there to be any contradiction because he hasn't been questioned about that.
Counsel, look, I'm not going to get into a back and forth dynamic of reply, and rejoinder. What you said is legitimate. The decision has already been made. In any case, later on in the judgment, if it harms you, you could assert what you are asserting now. But in any case, the Supreme Court's rulings are very clear. It's very clear. And as I have read the excerpts to you and its case law that binds this court, there is no room for debate. I'm not going to give the floor to more people anymore. Let's proceed. Let's listen to this statement.
He was in Milan.
Probably.
Yes, basically.
Did you have an employment contract? No.
No.
Permanent?
No.
No, not on that date. And in May 2017, where exactly were you working? Do you remember?
In May 2017, I was actively looking for a job. Having finished my master's degree in the first quarter, what I did was start considering different options to enter the job market.
How did you learn about the posting for the position of Conservatory Activities Coordinator?
Through a search engine, an internet search engine.
I guess that search engine would have directly shown the BOE or BOP publication from Badajoz.
Yes,
In fact,
with your permission, well, a few days ago I showed it to my lawyer. You do a search on Google on different search engines. You type in job offer, music teacher, Superior Conservatory of Salamanca, of Cordoba, of Musique en Musique in Smug. There aren't that many either. I think there are actually just over 20 higher conservatories, which were specifically the ones I was interested in. And that takes 15 minutes, and from there, as you said, it refers to the specific requirements, because there are some things I can't apply for due to my specific degree.
specifically, it came out on May 17th. How many days had you been looking for a job when you saw that announcement? Do you remember more or less?
Well, I did that on a daily basis. It's not really an activity that takes much time. I would do it before having coffee or while having coffee. Well, every morning you go through that routine. Also, I've been looking for other job openings, not just at conservatories. There are specific search engines that broaden the range. I also work internationally, so as a result, I use specific search engines as well.
But I mean, when you saw...
Right? That's the first part. Now the second. Let's patiently review all the parts.
Politics beyond my family connection, but come on, no.
What was your project about? I have it here and I've read it, just like you've read my order, but can you give me a summary? I mean, what I'm trying to say, David, so you understand me, if you didn't know the conservatories, because I suppose you had never come here to see them, nor had you been around here, nor had you visited them.
Well, I really like the Alentejo region in Portugal. As for the city of Badajoz, I had absolutely no knowledge about it. But then there's information, obviously, if you don't mind. Also, later on, remind me a bit about the general outline of the program so I can explain it to you. Because regardless of the fact that I presented a project, obviously reality takes over and you have to work with what you find, to put it directly. Yes?
Yes, if I...
Let's go to the third section.
A project, well, it seems logical to me that I made use of something that is my specialty, because one of my first jobs was working in an opera theater.
David, you remember when you presented the project, right? Then they notified you, well, the list of accepted candidates was published and they gave you a personal interview. Do you remember the interview, that personal interview? Were you all called in?
Yes, I remember. Well, this was a while ago, but I do remember that I had to come here because I stayed at the Ilunion Hotel, I think it's called, which is, well, it's now on the other side, yes. And there was a personal interview, yes.
Do you remember how long that interview lasted and what it consisted of?
Well, I imagine it was mainly a project defense where they could ask me questions about it.
But do you remember it?
If you don't remember...
Just say you don't remember.
Well, I can imagine what they would ask me about, like my degree, whether I spoke any foreign languages, if I had any previous experience. Honestly, those are questions I can imagine. If you ask me if I remember exactly what they asked me, well, no.
How long did the interview last?
I couldn't tell you how long it lasted either.
Not even approximately?
I don't know. Excuse me?
If you don't remember something, just say so honestly. It's not a problem.
What I can tell you is that it wasn't a 2-hour interview. Because, well, things are explained directly. There was a direct interaction with the people who were interviewing me, so...
How many people were in the interview? Do you remember, David?
I remember that later on there was a person I got to know, Manolo Candelija, who was and now is the current area director. Then there was also my first direct supervisor, Elisa Moriano. And I think I remember there was someone else, but forgive me, it's not out of disrespect, but because I think I've seen them later. But those are the people I worked with most directly.
And with whom you have had more contact later on?
Absolutely, very direct.
David, you signed the contract on July 10th, 2017. That's right, correct? You remember it perfectly. Yes, that's right. Do you remember exactly when you started working?
Well, honestly, it was immediately. They asked me to join. No.
Do you remember the exact day you joined? She doesn't remember.
I don't remember, sorry.
Symphonic band and chamber orchestra, coordination together with the management team of the conservatories for organizing series, preparing planning proposals, preparing periodic reports, all of these things that you surely know perfectly well, I suppose. Did you perform all these duties from the beginning?
Well, I believe so. In fact, I hope you are still continuing them today. Thank you.
Regarding what you just told me, for example, some of these duties that are verifiable and that I have requested from you, as you know, reports to the Provincial Council. For example, regarding orchestra conducting, which was given a lot of importance in your selection process. Why have you only conducted the orchestra twice in 2018, twice in 2019, and once in 2020? And then never again, according to the Provincial Council report.
Well, only I can conduct the orchestra because that comes directly from the academic program. So it's not like I want to conduct 5 concerts and have an orchestra at my disposal. It doesn't work that way. It always comes from academic activity. The concerts that I conduct are part of academic life. In that sense, it's always interesting to have guest performers as well. In any case, when I return from my leave of absence, I reconnect with the new management. In this case, it was Charo Mayoral. And with Yolanda, well, I see that they've already assigned someone else to direct these gatherings. And, well, I have no problem with that because, honestly, I have plenty of things to take care of. And I had quite a few goals to accomplish, and I have no objection to the decision they've made.
But that decision should have been made by you, since you were above them, right? I mean, in the organizational chart of the Provincial Council, it's clear that you are above the conservatories. Isn't the decision about conducting the orchestra up to you or the director or delegate rather than the conservatories? No.
No, because many times it's linked to a specific interest in inviting a particular person. It's a very small world. Maybe, well, not maybe, but during all these conversations that I have, which take place in a committee along with the management teams, the interest is expressed and what can bring the greatest benefit to the students is discussed. That's, let's say, that's the point. The specific point.
And is it true then, David, that since January 8th, 2020, you haven't conducted the orchestra again?
Yes, I have conducted the orchestra again, but it was already an orchestra made up of students, teachers, and former students. What happens is that now it's within the framework of Ópera Joven, which is a project that started in 2019. So,
I'll ask you about that later. Before we continue, David, regarding remote work, I have a report from the Provincial Council that says you have never requested remote work. However, in your emails, there is indeed a request for remote work. specifically from April 1, 2022 to May 22, 2022. Did you actually request remote work or not?
May 1st, I don't remember. I don't remember.
Do you want me to show it to you?
If you want, yes, please. But honestly, I don't remember requesting remote work.
You don't remember requesting remote work for that specific time I mentioned, and that you proposed coming in only every 2 weeks?
No, I don't remember.
If you don't remember, just say you don't remember.
Yes, I'm telling you.
You don't remember, do you?
No, I don't remember.
Very well. You were on leave of absence, David, from October 2020 to October 2021, right? Thank you.
October 2022. Yes, that's right.
And then you had paternity leave from April to August 2022. Thank you.
From April to August 2022. Thank you. Let's move on to the next section. And, well, if I have disagreements with people, then I have no problem with that. In fact, that difference was resolved because I continued with my activity and moved forward.
And David, for example, didn't you have any confusion about the responsibilities that were yours at any point?
Not at all.
Not at all. I'm telling you this because there's an email from you here, specifically number 679, dated May 28, 2018, yes? And you wrote to Elisa Morales?
Yes.
Elisa, good morning. Evaristo asked us to go to Santa Cecilia this morning, the 28th. This week to start determining and outlining with you the responsibilities that I will have to take on at the higher conservatory before things move much further ahead. Elisa, do you remember this? Why did you say this to Elisa? Do you remember that?
I don't remember exactly why, but what I do remember is that I'm quite exacting about the projects I put forward. And, as I've told you before, I have my own judgment. So that's a view that people may not share.
Of course, but you are specifically referring to determining and defining the responsibilities that I will have to take on at the higher conservatory before more confusion arises. What confusion was there? If your duties are clearly stated in your contract?
Well, I don't remember. I would have to ask Evaristo specifically, but I don't know. Because, look, I want you to understand that the number of activities I was managing at that time was quite large. Therefore, if we're talking about Christmas concerts, Santa Cecilia series, permanent series of young performers, the gatherings, the end-of-year concerts, the contemporary music concerts, and so on and so forth, the 9 symphonies of Beethoven, the labyrinth of the arts, yes.
But that has nothing to do with defining duties, which is what I'm asking you about. Your duties would be clear, regardless of whether you have more or less workload, but your duties would be clear.
What I have seen is that, indeed, I have always had to respect an academic standard. Because many of those activities that I have had to coordinate come directly from academic activities. All right. But besides that, I also have to set my own goals. The dissonance or confusion probably comes from those projects that I want to carry out. For example, if I want to put on an opera with the conservatory staff, well, that's going to add more workload. I understand that this can, well, be a bit uncomfortable because it's extra work that's being added. It's a workload that's being added to the already pretty heavy workload that conservatory teachers have. Because this, David...
In the organizational chart, it's very clear. I showed it to a witness yesterday because she seemed not to know it, that you are just above the 2 conservatory directors in the organizational chart. You do know that.
Well, I know that, but I want to tell you that I have never behaved that way. Well, I always, moreover, believe that I must respect and support the work of the teachers and the management.
But I'm asking you, David, because aside from how you personally carry out your duties, which is respectable, what I'm getting at with the question is that if you are just above the conservatories, above the directors of the conservatories, and your contract is to coordinate the activities of those conservatories, shouldn't you have ongoing contact with the directors of the conservatories? That's true.
Yes, well, I do have ongoing contact with the directors, yes.
Well, I mean the directors now? Because if that's the case, the last email you had with Yolanda was from August 2019. From August 2019 until now, you haven't needed any contact with this lady as part of your duties.
Well, actually, I do interact with her. I have interacted with her. That's another matter. It doesn't have to be by email. But anyway, I've always made myself available to my colleagues, and this kind of pyramid structure that you've described, honestly, I've never felt it that way. Because besides, it doesn't even make sense. If what I do is bring benefits to the conservatories, I need to understand what the director's own projects are, and of the teachers themselves. Because besides, they manage a group of students that is constantly changing.
Of course, and that's why, since you need that continuous information, I find it striking that your last email with Yolanda was in August 2019, and your last email with Maria del Rosario was in June 2023. She also said she hasn't had more contact with your work.
Well, contact by email. Well, honestly, I had quite a heavy workload, because at that time I had already established I was trying to win new venues so that when the time came I could bring in the conservatory students, the conservatory teachers, and the conservatory graduates. So once those territories are, so to speak, conquered, that is cross-border territory, a more significant presence in the territory, in different towns within the territory. As I already told you, the Provincial Council has that mandate for small and medium-sized municipalities. How can we reach them? Well, once that has been achieved, well, to resume and redirect again. Come on, I'm getting by.
Since when have you been involved in the Ópera Joven project, David?
Since 2019, I think that was the first production.
La primera producción.
Is it true that since that date you have been increasingly involved with this Ópera Joven and have left behind the duties listed in your contract as coordinator of the conservatories? Thank you.
No.
Isn't it true? Are you currently still performing all these duties that I just read to you, which are in your contract from July 10, 2017?
That's right. That's how I understand it.
I'm telling you because a Provincial Council report specifically says this.
Let's move on to the next section. It's a top-level private institution, and it also has all kinds of programs. Maybe what I wanted to complain about, or what I think I was complaining about at that moment, but it's a bit of speculation, it was that the conservatory needs for its own more organic development to have a clear identity, like the laboratory program. The opera I was already planning at the time.
David, have you ever had any intention, or do you remember requesting information about compatibility from the Badajoz Provincial Council so that you could perform other duties besides your own?
Well, it appears my lawyer told me about it, that I asked Emilia, which was the only time I made the inquiry. She resolved it, so the matter was closed.
Why did you want to request authorization? Do you remember what it was for?
I had found a project that could also serve as a platform to integrate students from the conservatory or from the conservatories in Portugal. This initiative was a cross-border initiative, and I expressed my intention to see if I could get involved in that project. The idea was that if I got involved, then obviously it will be the students and teachers from the conservatories that I coordinate. So in that sense, I asked if this was possible, and he answered me.
And they told you no, right?
And then that issue ended there.
What is true, and this is related to the issue of the restriction on outside work, is that this restriction has been removed from the essential conditions of your contract. In the modification of your position when it was modified, the change of title, as it is called by the council, they removed the restriction on outside work. Are you aware of that?
Well, to me, next block. Let the title coordinator of the conservatories remain, because in the end I'm still doing the same activity, and, well, if they want to change it, it's not something that concerns me.
So you found out after it had already been done? Yes. The change of name? And David, can you please explain to me, because yesterday no one could, what is the Performing Arts Office?
Excuse me.
The Performing Arts Office, what is it?
Well, let's see. I understand that it's the office in charge of performing arts.
I'm asking you because in the organizational charts of the Provincial Council, well, your position is currently called Head of the Performing Arts Office.
Yes.
So I'm asking you, if you are the head of the Performing Arts Office, what is the Performing Arts Office? Where is it located? Who is part of it? What does it do?
Well, it's the space where I continue with the work I've been doing since I joined the council in 2017.
And so physically, where is the Performing Arts Office located?
Well, I couldn't tell you. I mean, I imagine it must be in the office where I'm currently based.
And who else is part of it besides you? Are you the boss? If someone is the boss of something, they must have some subordinates. Who are your subordinates in the Performing Arts Office? Come on.
The first thing I want to tell you is that I don't have any subordinates. I mean, I have people I collaborate with, and they're still the same, people from the culture department.
Who are they specifically? Can you tell me their names? Who do you usually work with every day?
Well, quite a lot with Angel Seco.
Who is this gentleman?
Angel Seco is, well, no, I couldn't tell you what position he has, because honestly, it's not something that really concerns me either.
But what does this gentleman do? You work with him, so what does he do?
Well, I've worked extensively with him on designing all kinds of activities, even for the conservatories themselves. He has also assisted me in shaping all the strategic lines of the Ópera Joven program. Because now, the truth is that it's quite an extensive program. It has streaming broadcasts, conferences, and its own opera productions across 3 program areas.
And besides this gentleman, do you have anyone else you interact with every day?
Every day, well, I wouldn't say that, because honestly, as an institutional representative, I interact with many people. There's another person who's also joining now, and his name is Luis Carrero. He also takes part in the activities. Then we have the press office, where I obviously have to relay the events we want to highlight in the programs we run.
And are those people with you in the new office they gave you in May 2024, or not? No. Are you there alone? No.
No, that's not it, no. I'm not alone at the moment, but...
Who are you there with currently?
Luis Carrero is there?
Yes.
Thank you. But as I said, this person has joined recently. Thank you.
And until this gentleman joined, have you been there alone since May 2024 when they gave you the office?
No, I joined and, well, he showed up as well. Actually, there are 2 desks in the office. Well, he has his work and I have mine. It is true that Angel Seco, due to convalescence, has been absent from his work for quite some time, and I have had to cover some of the tasks, along with other colleagues. So I have approached both this new worker Luis Carrero, and I have also asked for direct help from Manuel Candalia. Or, well, depending on the objectives I had to meet.
What is your relationship with the President of the Provincial Council?
Well, a cordial relationship and a professional relationship. Thank you.
Do you often have meetings with him?
No, it's not very common.
In several of your emails, it seems you have meetings with him. You also mentioned that you spoke with him about the Ópera Joven project to present the idea to him.
Yes, he was quite interested in this regard. I think he's someone who naturally wants to stay up to date with what's being done.
Thank you. Isn't it more typical to meet with the area director or the deputy in charge rather than directly with the president of the provincial council?
I did that as well. In fact, I have had meetings and I've had to explain this project over and over again. To many people, even to the conservatory teachers themselves, who already understand that it really is one. It's an ambitious project that will bring a lot of work. So sometimes I've had to meet with Miguel Ángel. Well, I meet with him to explain what I think about this program. Thank you.
Where do you currently live, David?
I am currently living in Portugal.
Since when?
Well, since I started the work on my house, if I remember correctly, this summer, and since 2020 or 2000, end of 2021. When is it? When is the end of the pandemic? As soon as I return?
In 2021? Yes, in October 2021?
In October 2021, I had already moved to Portugal.
And have you been renting and then bought a house?
I bought a house, I moved, I did some minor renovations, and now I've gotten myself into a real mess.
How long have you lived in your own home, David?
Well, since I bought it.
How do you get to work in Badajoz each day? Do you drive your own car, use an official vehicle, or get here another way?
No, I have my own vehicle.
Do you come every day? Is it normal for you to come every day, or do you come once a week, once every 2 weeks? What is your usual frequency of coming to Badajoz?
If I don't have a specific meeting, for example, during that whole period when I returned after the pandemic, it started to have.
All right. Let's see. This is the first day, right? Yeah, first day. Now we start the second day, which is the day we've marked there, April 25th, April 25th. I mean, the statement that Mr. Sánchez gave on April 25th, can you give me a piece of paper? Can you write down, will you let me go out for me?
No, no, no.
The contacts listed in the UCO report and the ones you saw with me are the only ones you had with him, right?
Yes.
Look, apparently a series of phones related to you were also registered to this platform, to Irenbeek. Can you explain this to Your Honor, if she allows it? Why were there different phone numbers associated with that platform?
Well, it was already a pretty old account, so there was a lot of outdated information. They were phones that I was able to use at some point, and the numbers that I think they haven't been able to identify belong to a Russian couple who are friends of mine, who used to give them to me in the past to manage the account.
Look, in those days, when you were exchanging those messages through that platform, had anyone already assured you that the position you were a candidate for was definitely going to be assigned to you?
Well, absolutely not. In fact, if I mention that I'm going to work in Badajoz, it's so that he can offer me a rental rate. Not a tourist rate, since it's a platform for tourists, but rather in line with the salaries that are standard in the region. In other words, I can't approach a landlord without being able to assure him that I'll have an income to cover the monthly payments. Thank you.
And apparently it's also a rule on this platform to limit the rental period. Is that right?
Well, actually, it's simply a requirement in order to be able to talk to the landlords. Not only was the territory already much larger, but the performing arts cover many disciplines.
The fact that this administrative unit was called an office meant that the administration provided a specific physical place where a little red sign could say office.
No. Well, this is something I couldn't clarify last time, and I appreciate the question. The office, the Performing Arts Office, was not a physical place. It was an umbrella of activities that tried to serve as a platform to be able to promote the local resources, the resources of the artist, to be able to promote, based on the cultural revitalization plan, their own productions.
And since it was the successor to the management of the conservatories, it kept the same administration, that is, it kept the same headquarters as the management of the conservatories.
What does that mean? This is not the same.
I understand it. You worked at the same place as a director and as part of the Performing Arts Office management.
Yes, well, but if I want to...
To clarify, I'm asking you to confirm, with Your Honor's permission, that calling it an office was just an administrative classification, not that there had to be a building or even a little hut for it to be an office.
Yes, that's true. That's definitely true, because there wasn't a little sign that said, "This is the technical office." No. It was an activity, or at least that's how I understood it, even though in the end it's something that I wasn't consulted about either.
And from a functional point of view, you say that when this office was created, there was an expansion of the projects, of the activities carried out in the area of culture, right? Precisely because of that change in name.
Yes. Well, there were several synergies. One, and I think that...
All right, thank you very much. Therefore, as agreed by this court, the statement given in recent days by Mr. Sánchez has been introduced into the proceedings as requested by the popular accusation Manos Limpias. Next. Final submissions. With the clear understanding Yes, you're right, my dear colleague. Mr. Sánchez, please stand up. If you wish, you may add anything you consider appropriate. If you'd like to add anything, there are no questions from the parties. If you want, in light of what you have written there or what you have said before, to add something or not add anything as you wish.
As you say.
Only if you want to. It's a right that you have.
But if you don't have any point that I need to clarify, then I have nothing else to say.
Very well. Sit down. Thank you. Very well. Let's see. Once this procedure is completed, as established by the Supreme Court ruling we've already mentioned, we move on to the conclusions procedure. Now, I'm going to explain something and I'm going to be strict. The conclusions procedure, as you know, is different from the closing argument. You must either submit the final conclusions or propose up to 3 modifications. Nothing else. No arguments are allowed for now. You'll have time for that later. You will have time for that on Monday, with the closing arguments on Monday and Tuesday. Plenty of time for both sides to present their views. Counsel for Manos Limpias, you have the floor.
With your permission, Your Honor, we will modify.
You understood that, right?
Yes, perfectly. With your permission, Your Honor, we are going to partially modify our conclusions. We have brought it in writing. We are going to upload it to the digital file right now.
It must be uploaded to the digital file by 11 a.m. tomorrow.
Yes,
In the interest of everyone's right to a defense.
Well, we have provided a copy. All parties have a copy. Do all parties have a copy? During the break, we gave a copy to all the to all the defense teams. And I believe all the prosecutors also have their copy. I brought the 3 originals for Your Honors.
Thank you very much, Counsel.
It's underlined, as I mentioned earlier during the recess to the defense. What's been modified is underlined, which is very brief, and I will summarize it so that it is recorded. Is that okay?
Perfect. One moment. I'll let you know when I start.
All right. The first modification is on page 27, as you can see, Your Honor. On page 27, in the first of the offenses, when I say those described in the first heading to, well, we have abided by the court's ruling, and therefore, regarding the offense we charge Mr. David Sanchez with, the one under Article 406, we declare that it is time-barred. And therefore, we stated it as such in our final written submissions. If we go to the next page, page 28, when we talk about the crime of influence peddling in a linked offense structure, with a crime of unlawful administrative decision-making and illegal appointment, Articles 429, 404, 77, 77.1 and 3, and 406 of the Penal Code. Here, well, what we state, which is also underlined, is, and that's why I say it, I read it so that it is on record, is about said crime. During preliminary proceedings, the court excluded the accusation solely against the defendant from the trial's scope, Mr. Miguel Angel Gallardo, so the matter must remain undecided as to Mr. Miguel Angel Gallardo, reserving in any case this party's right to bring charges again on that basis against him, since he will not be judged for that crime. On the next page, page 29, regarding the crime of illegal acceptance of appointment under Article 406, Section 2 of the Penal Code, allegedly committed by Mr. David Sánchez Pérez Castejón, declare it time-barred. This is where we are making the accusation person by person. If we go further ahead, in Part 3C of that same page, when discussing the ongoing crime of influence peddling in a linked offense structure with administrative misconduct and illegal appointment, you'll notice some dashes are underlined. That's where the name of Mr. Miguel Angel Gallardo was, which has been removed in accordance with the court's decision on the page. Perfect. En la página 31, here we are already talking, well, at first we were already talking about the sentences, and specifically about the sentences for Mr. Miguel Angel Gallardo. Well, in Section C on that page 31, we are saying that as provided in heading 1C, the same crime has come up in the context of its justification in the present case with respect to the accused. The accused is Mr. Gallardo. If we continue on page 33 of our document regarding point number 6, related to Mr. David Sánchez Pérez Castejón, obviously, well, regarding the crime set forth in Section 406 in heading 1A, Article 406 of the Penal Code, it is not appropriate to impose any penalty since the offense is time-barred, logically. Lastly, we have included on page 35, we have added one more clause, the 7th, and that is, I will read it to you verbatim, the costs should be imposed on the defendants, including those of the popular prosecution, that is, the costs incurred by the popular prosecution, since it was essential for the prosecution of the case. As for the rest, Your Honor, as to everything not modified, we adopt our conclusions as final. That's all. Thank you very much.
Very well, very clear. The court appreciates this. Very well. Now, counsel for Acte Oyer, thank you.
With your permission, regarding the conclusions, we are changing the second one in all 3 points, in all 3 sections, A, B, and C. In Section A, where at the time a continuing offense of malfeasance in conjunction with an offense of illegal appointment was established, we are modifying it to an offense.
One moment, counsel, yes. You are referring to which conclusions?
to the conclusions in the May 14, 2025 filing of the document from May 14, 2025 submitted by the then Unified Prosecution. So it's on page 25.
Do you have them in writing?
We have already submitted them. I mean, they have been submitted digitally, but not in writing because I haven't found where to print them. All right.
But wait a moment. But you have already added them to the digital system.
Yes, of those we've been working on since 6 o'clock.
Well, then it has to be in the digital system. This is fundamental.
Yes, we've sent it to the attorney, and in theory he has confirmed the filing.
It's just that at the same time, it shouldn't prejudice the other side's defense. But anyway, please give a brief description of the changes.
Well, briefly, because it's the same in Block 1st A, 1st B, and 1st C, the blocks are going to be the same. It is a crime of administrative malfeasance under Article 404 of the Penal Code, combined under Article 77, Sections 1 and 3, with an offence of influence peddling, respectively, under Articles 428 and 429.
And that, sorry, Your Honor, 1 second, I'm not following. I would appreciate it, since we don't have a copy, if you could show the first version and the modified one.
The page, if possible. Well, page 25, but it's just that in... Wait.
Counsel, that's something I'll have to decide, right? All right. Yes, you make suggestions to me and I decide whether to do them or not, of course. I don't give orders to the other party. Yes, no, it's to keep
Always with your mediation.
Very well, I appreciate it. Do what your colleague has suggested.
On page 25 of the indictment, where it says 1, those described in the first section A, that stays the same, and from there, letter A and B are changed, they are removed, leaving only one paragraph that will say, a crime of administrative malfeasance under Article 404 of the Penal Code as a linked offence, according to Article 77, Sections 1 and 3, with a crime of influence peddling, respectively, under Articles 428 and 429 of the Penal Code. Anyway, it's already uploaded. Thank you.
Yes, go ahead.
As for...
Please, let's be quiet.
On the same page 25.2, which said those described in heading 1B, that stays the same, those described in heading 1B, and points A and B are removed. It's going to be exactly the same paragraph I just read, because it's going to be identical. An offence of administrative malfeasance under Article 404 of the Penal Code as a linked offence, according to Article 77, Sections 1 and 3, with an offence of influence peddling, respectively, under Articles 428 and 429 of the Penal Code. In other words, exactly the same, except for the second offence about changing the nomenclatures. And as we continue on the same page 25, what was stated in point 3, those described in heading 1C, that remains, and the next two paragraphs are removed, which are replaced again, which I think I don't need to read again for a paragraph that's exactly the same, except in the last part, well, or I'll read it, so that way we don't have to note any caveats. An offence of administrative malfeasance under Article 404 of the Penal Code in medial concurrence, according to Article 77, Sections 1 and 3, with an offence of influence peddling under Article 404, 429, and here is the difference, or alternatively, under Article 428 of the Penal Code. It's the same as the previous two paragraphs, but it's no longer from Articles 428 and 429 of the Penal Code, but rather 429, or alternatively 428. So regarding the third conclusion, which was about those who are criminally responsible, those who are criminally responsible for the aforementioned crimes, either as perpetrators or as accused. The third, for greater clarity, I will read it in full as it stands. The third A refers to those mentioned in heading 1st A, cited above, as direct perpetrators in the context of a medial concurrence. Between the crime of administrative malfeasance under Article 404 of the Penal Code and the crime of influence peddling under Article 428 of the Penal Code, They will be Miguel Ángel Gallardo Miranda, Elisa Moriano Morales, Cristina Núñez Fernández, and Félix González Márquez. And as an essential accomplice or alternatively instigator, persons without official status in the offense of administrative malfeasance under Article 404, and as the perpetrator of the crime of influence peddling under Article 429, David Sánchez Pérez Castejón. So are all the statements from the group, from the one listed in the first day, all as perpetrators, but David Sánchez simply as a necessary participant or alternatively as an instigator? Regarding the heading I mentioned before, first B, that is the one about the change of nomenclature, it's the same thing. As perpetrators who are insiders in the linked offenses between the crime of administrative malfeasance under Article 404 of the Penal Code and the crime of influence peddling under Article 428, well, perpetrators, Francisco Martos Ortiz, Emilia Parejo Gala, Juana Cintas Calderón Zazo as a necessary participant, Miguel Ángel Gallardo Miranda as a necessary participant or alternatively instigator. And then David Sánchez Pérez Castejón as a necessary participant or alternatively instigator. And regarding letter C, the section we previously called C, which was the creation of the position that was ultimately awarded to Mr. Carrero, well, the same. The perpetrators of the linked offenses among the aforementioned crimes are Ricardo Cabezas Martín and Manuel Candal Candali Jabali. And as necessary accomplices, or alternatively as instigators, Luis María Carrero Pérez, and, if applicable, David Sánchez Pérez Castejón. The first one, well, and both for the same charge, 429, or alternatively 428. And so, anyway, that's already been uploaded. That's regarding participation in the crime. Circumstances modifying criminal responsibility, no change was established. It remains the same. And regarding the fifth conclusion, which was the penalties we were requesting to be imposed, I'll read it, well, since I've submitted it in writing, but nevertheless, for further clarification, for the crime. In the case of Miguel Ángel Gallardo Miranda, for the crime of the first A, the creation of the first position, and I will not go into the linked offenses, the same, for the crime. First, 10 years of special disqualification from public employment or office and from exercising the right to passive suffrage, 2 years in prison, a fine of double the benefit obtained by Mr. David Sánchez Pérez Castejón, equivalent to the total salaries and emoluments received as coordinator of activities of the conservatories in the amount to be determined in the execution of the sentence. And for crime B, because crime C, in the case of Mr. Gallardo, we have withdrawn it. For crime B, the one provided for in section 1B, which appeared in the initial document. 9 crimes, 9 years of special disqualification from public employment or office and from exercising the right to passive suffrage, 2 years in prison, and a fine of double the benefit obtained by David Sánchez Pérez Castejón for the second accused, Elena Moriano, and for the crime provided for in section 1A, this is the total disqualification received, the same for public employment or office and for exercising the right to passive suffrage. Two years in prison and a fine of double the benefit obtained by David Sánchez Pérez Castejón. As for the third, Cristina Núñez Fernández, it is only the only one for Gallardo, equivalent to the salaries and emoluments received by David Sánchez Castejón, equivalent to the salaries and emoluments received by David Sánchez Castejón. Prison. Por el delito es el único de la primera A, es el único de lo que acusamos, 10 años de inhabilitación, 1 año de prisión. And for the crime of the first B, 9 years of disqualification, 1 year and 6 months of prison, and a fine of double the benefit. In the case of Mr. Gallardo, equivalent emoluments received, also equivalent to the total emoluments received. Of disqualification, 1 year and 6 months for Pérez La Parejo Gala, also only for the first time, 9 years of disqualification, 1 year and 6 months of prison, And for the first time, we request 9 years of disqualification, 1 year and 6 months of prison, and a fine from C. The eighth, Ricardo Cabezas Martín for Gallardo, total disqualification and equivalent to the salaries and emoluments received, Sánchez Castejón, and a fine of double the amount for Mr. Gallardo, equivalent to the total of the salaries. Emoluments, Carreño Pérez for Sánchez María Carrero Pérez for the first C, fine of double the benefit. And now, as something new compared to the others, prohibition from contracting due to the crime to the totality of the salaries and regarding emoluments received by the first up. 10 years of disqualification, 2 years, Pérez Castejón, and the crime provided for in the first heading because Gallardo to the emoluments received for 2 years by David Sánchez Pérez Castellón. 9 años de inhabilitación, 2 años de prisión. And for the crime provided for in the Gallardo, equivalent to the totality, salaries and emoluments of the benefit. And we also request the discretionary reduction of the penalties provided for in Article 65.3 with respect to David, under Article 65.3 regarding the visa, Pérez Castejón, and Luis María Carreno Pérez, but we also request civil liability and restitution that was already included, and we also introduce as a new element the conviction for the crime of the totality of the popular salaries and emoluments received, as confirmed again by the court representative. The summons document has already been uploaded. Well, another Pérez, since only the private prosecutors have maintained the charge. It's already uploaded. The court representative confirmed it again.
Crime. Mr. Gallardo, equivalent to the total salaries, Lozano, emoluments received, Sánchez Pérez Castejón. Counsel, your turn.
Mr. Gallardo cannot be committing a crime equivalent to the total salaries and emoluments received by Sánchez Castejón.
For the crime, Gallardo,
equivalent to the approval of all salaries and emoluments, he has already substantially submitted a document, assuming a document presented by the People's Party. Substantially, there is agreement on the inclusion of the specification of certain events in the facts as seen within the established framework. Sánchez, there is agreement on the inclusion of the specification of certain events in the facts as seen within the framework established in the order and for the crime, Mr. Gallardo, equivalent to the total penalty, the salaries and emoluments received by Sánchez Lopérez for. In order not to repeat what they added,
are you going to defer to what your colleague representing the People's Party is going to say?
Yes, Your Honor.
All right, then I will give the floor to counsel for the People's Party. And then we'll go with both of them.
With your permission, Your Honor, I would like this to be distributed among the members
of the court. Yes?
Yes, I wanted to ask that this be distributed among the members of the court and defense counsel, which is the document we have already submitted and is already included in the digital file. Thank you. But it could continue here now. Your Honor, please.
For each of the attorneys and for the prosecutor.
Including the secretary. Yes, but also for the prosecutor. I mentioned the defense since that's who's being addressed. One moment.
One moment. She also plays the prosecutor?
Of course. It's a slip for which I apologize to the prosecution, but that's the role I understood he was playing. All right then. One moment. Sorry.
Yes. Thank you. Now it's your turn, again.
Thank you very much. With your permission, Your Honor. As my colleague from Vox has said, we have indeed submitted a document in which we have added some events to the statement of facts, without changing the factual account at all, simply for the ease of verification and checking the work of the court. And we move on to the second conclusion, which is the legal characterization, in which we have provided a complete account of the reasons that justify it. In our opinion, the possibility of establishing a procedure that we are now carrying out of separate final submissions. And therefore we offer an independent legal classification regardless of the nevertheless brilliant document and classification that was previously submitted by the Unified Prosecution. I believe that for the purposes of recording and defense rights, the documents include the one we have submitted. I don't think it's worth detailing now. It's 15 or 20 pages simply referring to the facts or to the legal classification that we believe should be given to those facts. On page 26, we believe that the facts described in the first heading A are constitutive of a crime of influence peddling committed by a private individual as set out in Article 429, a crime of influence peddling committed by an authority or public official as set out in Article 428, and a crime of administrative misconduct as set out and punished in Article 404. Perhaps to clarify, we have explained earlier in the part I have not read aloud that one thing is the statute of limitations for a specific crime for which someone was initially accused. And another thing is the statute of limitations for the facts that have not expired. And the facts that have not expired can now be classified according to different offenses without obviously changing the essential nature, which is what we are doing. The crime of illegal appointment may have become time-barred, but not the acts that were committed, as we understand, by the accused. Regarding the acts described in Article 429, a crime of influence peddling committed by an authority or public official as provided for and punished in Article 428, and a crime of official misconduct as provided for in Article 404. And regarding the classification on page 33 of the acts described in Section C, a crime of influence peddling committed by a private individual as provided for and punished in Article 429, and a crime of official misconduct as provided for and punished in Article 404. We detail on page 34 and the following pages the authorship and participation of each of the accused in these criminal acts. The details are set out there. Regarding the crime set out in Section A, it constitutes a crime of influence peddling committed by a private individual or as a principal, Mr. David Sánchez Pérez Castejon, of the crime of influence peddling committed by an authority or public official. It is a crime. The person responsible, Miguel Ángel Gallardo Miranda, and for the crime of official misconduct, Mr. Miguel Ángel Gallardo Miranda is responsible as the principal, and as an instigator or alternatively as an accomplice, Mr. David Sánchez Pérez Castejon. As necessary accomplices, under Article 28, subsection B of the Penal Code, we believe that Ms. Elisa Moriano, Ms. Cristina Núñez, and Mr. Félix González Márquez should be convicted. For the crimes in Section 1B, Mr. David Sánchez Pérez Castejon is liable for influence peddling by a private individual, and Mr. Miguel Ángel Gallardo Miranda for influence peddling by an authority or official. For the crime of official misconduct, Mr. David Sánchez Pérez Castejon is responsible as the instigator, Mr. Miguel Ángel Gallardo Miranda and Mr. Francisco Martos Ortiz as the perpetrators, and Mr. Juana Cinta Calderón Sazo and Ms. Emilia Parejo as necessary accomplices. And finally, for the crimes listed in Section 1C, for the crime of influence peddling committed by a private individual, Mr. David Sánchez and Mr. Luis María Carrero Pérez are responsible as perpetrators. For the crime of official misconduct, Mr. David Sánchez Pérez Castejon and Mr. Luis María Carrero Pérez are responsible as instigators. And as necessary accomplices, Mr. Ricardo Cabezas Martín and Mr. Manuel Candarija Valle. The penalties are described on page 36. Well, we are going to list them. Given the seriousness of the acts in the first conclusion, I impose the following penalties on each defendant. To Mr. David Sánchez Pérez Castejon for the crime of influence peddling as the main perpetrator in conjunction with the crime of administrative misconduct, as an instigator or, where applicable, as an accomplice, as provided in Section 1AA, the penalty of 2 years in prison, a fine of double the benefit obtained. Prohibition from contracting with the public sector, loss of the possibility to obtain public subsidies or aid, and loss of the right to receive tax or social security benefits or incentives. For 10 years plus special disqualification from public employment or office, and from the right to stand for election for 8 years. For influence peddling as a principal offender in a linked offense with administrative malfeasance as an instigator under Section 1B, the penalty is 2 years in prison, a fine twice the benefit gained, a ban on public sector contracts, and loss of eligibility for public subsidies or aid, loss of the right to receive tax and social security benefits and incentives for 10 years, along with special disqualification from public employment or office and from the right to stand for election for 8 years. For the crime of influence peddling as a principal offender in a linked offense with the crime of administrative malfeasance as an instigator as provided in the first section. C. To the penalty of 2 years in prison, a fine of double the benefit obtained, prohibition from contracting with the public sector, as well as the loss of the possibility to obtain subsidies or public aid, loss of the right to receive public benefits or aid, and tax incentives. From social benefits for a period of 10 years, and special disqualification from holding public employment or office, and from exercising the right to passive suffrage for a period of 8 years. To Mr. Miguel Ángel Gallardo Miranda, for the crime of influence peddling in a linked offense with the crime of administrative malfeasance, both as an instigator as provided in Section 1A, to a prison sentence of 2 years, a fine of double the benefit obtained, and special disqualification from holding public office or employment, and from exercising the right to passive suffrage for a period of 20 years. For the crime of influence peddling in a linked offense with a crime of administrative malfeasance, both as an instigator as provided in Section 1B, to a prison sentence of 2 years, a fine of double the benefit obtained, and special disqualification from holding public office or employment, and from exercising the right to passive suffrage for a period of 20 yeyears. To Ms. Elisa Morellano Morales, for administrative malfeasance as a necessary accomplice under Section 1A, sentenced to 7 years of special disqualification from public employment or public office, and from the right to stand for election. To Ms. Cristina Núñez Fernández, for administrative malfeasance as a necessary accomplice under Section 1A, the penalty is special disqualification from public employment or office and from exercising the right to passive suffrage for 8 years. To Mr. Félix González Márquez, as a necessary accomplice in administrative malfeasance under Section 1A, sentenced to special disqualification from public employment or office and from exercising the right to passive suffrage for 5 years. To Mr. Francisco Martos Ortiz, for administrative malfeasance as principal under Section 1B, the penalty is a 10-year special disqualification from public office, employment, and passive suffrage. Ms. Emilia Parejo Gala is sentenced as a necessary accomplice to administrative malfeasance under Section 1B, receiving a 6-year special disqualification from public office, employment, and passive suffrage. To Ms. Juana Cinta Calderón, for the crime of administrative malfeasance as a necessary accomplice under Section 1B, sentenced to special disqualification from holding public office or employment and from exercising the right to passive suffrage for a period of 5 years. To Mr. Ricardo Cabezas Martín, for administrative malfeasance as a necessary accomplice under Section 1C, the penalty is special disqualification from public employment or office and from exercising the right to passive suffrage for 6 years. To Mr. Manuel Candarilla Valle, for the crime of administrative malfeasance as a necessary accomplice under Section 1C, sentenced to special disqualification from holding public office or employment and from exercising the right to passive suffrage for a period of 5 years. Finally, to Mr. Luis Maria Carrero Pérez, for the crime of influence peddling as the main perpetrator in conjunction with the crime of administrative malfeasance as an instigator under Section 1C, sentenced to 2 years in prison, a fine of double the benefit obtained, prohibition from contracting with the public sector, as well as the loss of the possibility to obtain public subsidies or aid, and the right to enjoy tax benefits or incentives, and social security benefits or incentives for 10 years, and special disqualification from public employment or office and from exercising the right to passive suffrage for 8 years. We did not include this in the written statement, but we now verbally add the request for the defendants to pay the legal costs. Thank you very much, Your Honor.
All right. Asociación Liberum.
With the permission of the Honorable Court, this party has submitted a simple document through LexNet in which we fully adhere to the final charging submission of the Partido Popular.
Very well. Association and Justice of Europe.
With the Court's permission, we fully and completely join, without any reservation, the statement of charges made by Actio IR, and as a result, we make it our own. And, well, to clarify, something similar happened to us as it did to our colleague. The attorney has the document, and it is pending its inclusion in the court file today. Thank you very much.
Very well. As soon as you have it, you know, the court file before 11 and the 3 copies. All right. Final submissions. Madam Prosecutor.
With your permission, Your Honor, final submissions.
Final submissions, yes. Counsel, sir.
With your permission, Your Honor, we will now address the change of...
The conclusions of the no, it's simply final submissions, sorry. Final submissions, then there will be time for the closing argument. There is enough time, counsel.
With your permission, Mr. President, I will make my final submissions with one qualification that you will allow me to present for the sake of procedural consistency. At the beginning, in preliminary matters, I mentioned a possible modification of the provisional conclusions, which definitely will not take place. Thank you.
Very well. Counsel, proceed to final submissions. Mr. Attorney, with your Honour's permission, I will now make my final submissions on the provisional matters raised earlier. Are you feeling better, Mr. Attorney? Yes, I'm holding on here. I'm glad. Counsel, proceed to final submissions. Counsel, proceed to final submissions. Proceed to final submissions.
With your permission, Your Honor, to correct a clerical error we noticed in our filing where it says private prosecution, it should say popular prosecution.
In all other respects,
We stand by them as final.
very well. We have finished today's session. And then Monday the 8th at exactly 9:39:25, the session resumes with the closing arguments.
Excuse me, Your Honor. So I understand that the procedure under Section 758.5 is postponed until Monday.
Yes.
Thank you.
Let the prosecutor clarify that.
Yes, since they have changed, the private prosecutor's position has changed substantially. The law then provides that, during the discussion, it is possible to report on the viability and compliance according to the law, in light of the substantial changes made. And if the defense teams can request a one-day extension to make the necessary corrections.
All right, you have the floor.
Yes, you do.
Ma'am.
I haven't had time to read them, but from the little I've read, I've noticed there's a variation. Here is the microphone. There is both a factual and legal variation of the facts that were initially presented in the private prosecution's filing, now that everything has been unified. New crimes have been added that violate the rule that the charges define the case and are not homogeneous. Other people have been accused again, or rather, for the first time, of crimes. I thought that Vicente is being accused now. All right.
Is that the conclusion in the note?
The conclusion is that they cannot be accepted. It violates what is stipulated by the law.
Yes, let me explain, Madam Prosecutor.
Yes.
He is invoking Article 700.
88.5, I think they shouldn't be admitted, except for the one presented by Manos Limpias. If you want exactly the same. Thank you.
All right, let's see. 781.
You can't make a substantial factual variation of legal relevance. You can't subjectively modify either the facts or the criminally responsible persons. Variations can only be made in vain. You can't modify the participation.
Let's go. Yes, above all, Counselor. Should I say something?
I also wanted to speak on that point.
Yes.
With your permission, Mr. President, the limit, Your Honor just said it.
The limit on any amendment is inviolable respect for the facts, apart from purely secondary points. If we read the document, which you were kind enough to provide, you have marked the differences, and if I may, grammatically speaking, it's Mao's little red book. I mean, everything is red. The modifications go beyond a substantive point. That's regarding the facts. The modification of the facts is inadmissible. And regarding the change in legal classification that has been introduced, where before there was only one, in the group of first-degree classifications, there was only one crime of malfeasance in concurrence with an unlawful appointment. Now, influence peddling is being added, or introduced, sorry. This is a change in the legal classification, for which Article 788.5 allows the defense, and I respectfully request it, a 10-day postponement so that I can prepare a defense for a new charge that I am learning about during final submissions. That's all. Thank you very much, Your Honor.
The court will deliberate on this new matter. Your Honor, with your permission, yes, you gave everyone 2 minutes to speak. We have Mr. Cortez, yes, very briefly.
Yes, with your permission, Your Honor, because in substance I agree both with the Honorable Representative of the Public Prosecutor's Office and with the attorney who spoke before me. The point is that I think we have to go back to the simple request for a 10-day postponement. At least this party understands that such a postponement would amount to an acceptance of the procedural developments now taking place. No. What this defense respectfully requests from this court is that it find that we have been denied the ability to defend ourselves. And that in any case, regardless of whether we use the 10-day prerogative, Because the Supreme Court didn't do it, the High Court of Justice can require it from us in order to formally address that claim of defenselessness. I believe this court is technically capable of clarifying, studying, and rigorously analyzing what is being presented to us here, which obviously amounts to manifestly unexpected charging theories. Ultimately, I am moving ahead of what my colleague said, still understanding that alternatively or subsidiarily, if there were a declaration of constitutionality regarding what is being presented to us by the court, then the 10 days would indeed be set in motion. But first, respectfully, we believe that this court must conduct a rigorous analysis of whether what has just been presented to us is truly compatible or not with the right to a defense and the effective judicial protection guiding Spain's democratic process. Thank you.
Mr. Mendoza, you have the floor. I join the request made by the previous attorneys.
Yes, to avoid being repetitive, we also join in what has been expressed
By my colleagues.
Yes, with the permission of the Honorable Court. We are going to join in what has been stated, and we will also specify that it is within the strictest procedural legality. The criminal procedure law allows the prosecuting parties to present their final submissions at this stage. And I read Article 788, Section 4. Well, no, I'm just saying. That possibility is only limited to the classification, to the penalties, and to the degree of participation, but under no circumstances at the stage of final submissions. This is unheard of. The factual account can be modified in such an overwhelming way as the People's Party's private prosecution has done, and to which other private prosecutors have joined it. This, Your Honors, should be, in the opinion of this humble attorney, absolutely rejected outright by the court, because it constitutes a complete violation of the fundamental right to a defense. Introducing now, at the final submission stage, factual elements on which it has not been possible to exercise and assert the right to a defense. That could not have been addressed through the evidence presented during the trial. It is completely inadmissible and must be rejected outright by the court.
Counsel?
With your permission, Your Honor, and without setting a precedent, we would like to be precise. Obviously, we oppose the new charging briefs filed from Hazet Oir onward, because there is a brief that is indeed orthodox and is in line with the provisional conclusions brief, which is the one from Hazet Oir. The one from Manos Limpias, which abides by its own provisional charging submission and also what Your Honors established at the beginning of this trial. The rest of the charging briefs are a complete subversion of the terms of the debate, of the penalties and the substantial elements, as the public prosecutor has rightly pointed out in the process. The law also obliges us to request precisely that procedure, the one under 788.5. Otherwise, we would not be able in the judgment to allege the manifest prejudice to our defense that is being caused to us now. There is a remedy, as my colleague Mr. Emilio Cortés has rightly pointed out, which is to absolutely and outright deny once the court reviews them, because these new charging submissions are indeed prejudicing the party's defense rights at this moment. And that way, the schedule would also be followed and fulfilled, which I believe was rightly established, without this illegitimate interference with these parties' defense rights that was decided at the time. Only in this way could the procedure continue through its normal channels. What has happened today is an intolerable abnormality. Thank you, Your Honor.
With the court's leave, we fully support what was stated by the public prosecutor, and we understand that, indeed, the right of defense is not guaranteed with this unexpected contribution from the private prosecutors. We recognize the right to effective judicial protection and fully support the statements of the public prosecutor and the defenses.
Counsel?
Yes, with the court's leave. Purely for procedural and time-saving reasons above all, because all the attorneys here have various professional obligations. To postpone the proceedings for 10 days, with the proceedings suspended in the meantime, it harms everyone. In this regard, we are going to support the request formally made by the defense of Mr. David Sánchez and all the other colleagues who have joined in this regard.
Very well, yes. The court hardly has any work. Counsel, you have the floor.
Yes, with your permission, Your Honor. With your permission, well, Attorney for Manuel Manolimpias, I stand by the written final submissions we filed. And I'm not going to comment on the filings submitted or on the final submissions advanced by the other prosecution parties. Thank you very much.
Counsel?
Yes, with your permission, to oppose the other side's request, I don't know. No, my computer is off, so I can't look up the articles. Honestly, I think some citations are not applicable. First of all, the 10-day period, which I believe is not in 788.5, if I remember correctly, it's the maximum limit. It can be suspended in some cases, which we will specify up to the maximum limit of 10 days. Today is Thursday. The final statements or conclusions are scheduled for Monday, which will most likely be the prosecution, and for Tuesday, the defense. So first of all, there would be enough time. Second, if I'm not mistaken, 788.5 is for when, upon requesting higher sentences, the court that was handling the case lacks jurisdiction. The criminal court with reforms and all that, but anyway. What is clear is that in the document, in the final charges requested by this party, we have left untouched. The facts are untouchable in that regard. We haven't touched a single fact. We have changed the legal classification. That's true. Logically, when it comes to provisional charges and final charges, it's because they can be changed. And we have changed them while maintaining the criterion of homogeneity and without altering the facts. The factual identity is clear. And what we have added in the first case, in Block A, is the crime of influence peddling. The crime of malfeasance was already there, and what is being protected is the same. It's the administration's impartiality and objectivity. The protected legal interest remains the same. That's our understanding. And another thing is, honestly, we are not going to say anything about the other document that may have been submitted, because we haven't been able to read it, or if anyone has joined it. We haven't touched the facts. And as for the facts, yes, they can be specified. What cannot be done is to include new facts. Let's keep in mind that even in the original indictment, there was already reference anyway to the reports from the UCO. I don't know about emails. And as I said, I haven't been able to analyze the document, whether these are new facts or those that were in the indictment by reference and are now stated again. So, of course, we object
to having it postponed, and if so, since we have until Tuesday to intervene, it can be done then without prejudicing the defense. Madam Attorney, you have the floor. Yes, Madam Attorney.
With your permission, Your Honor. This party adheres to what was stated by the attorney for the other party, wanting to emphasize that the facts have not changed. And at no point has there been any substantial change in the legal grounds. As my colleague has rightly pointed out, the change still involves the same legally protected interest. Therefore, considering also that the facts remain the same, no prejudice has been caused to the defendants. Thank you very much.
Your turn. On behalf of Vox, Your Honor, Honorable Court, we must point out two issues. One, that it was already made clear in the order the possibility of making the interpretation or nuance of each of the private prosecution parties. That is one of the most important points. Even so, this party has not made, in the document it has submitted, which is substantially in agreement with what was expressed by the PP, has not made any new factual contribution. Is it true that in the 27 pages of the document, events are added, details of facts that are already included in the proceedings and that are already there? As I said at the beginning of my statement, when Your Honors gave me the opportunity to express our position, what is being done is a clarification of the events that improves, enriches, and also gives more opportunity even to the defense as a safeguard, to be able to analyze those that we consider not only the most relevant but also decisive in shaping it. Are the facts analyzed consistent with what we had been assuming, since by legal requirement we had to assume from the presentation of the accusation filed by Manos Limpias that there is no prejudice to the defense because the factual framework is the same. It is true that the law allows it. 788 is precisely for that, and the established case law, which Your Honors are familiar with, regarding the possibility of this factual interpretation. And we have to remember that the common framework is that of malfeasance and influence peddling. What has been done at this moment is the delimitation, even greater specification regarding who committed the acts, each person's participation, and therefore the penalties as well. So we are perfectly fine without even needing to grant the 10-day period or any extension, because the legal classification has not changed. The crimes remain the same, all the defendants have testified about them, the factual events are the same, and it's true. And allow me to also state that given the overwhelming evidence, we wouldn't need to specify events that could be relevant for the appropriate purposes. also to justify the aggravation that is also being requested in the penal part, which we believe would not be appropriate. And regarding the suspension, because we are completely within the limits set out in Article 788, thank you, Your Honours.
With your permission, Your Honor, distinguished court. To avoid being repetitive, we fully support the explanations given by the legal representative of the Vox Party and also those that will be made by the representative of the Popular Party.
With the court's permission, Justicia Europa opposes the arguments made by the defense regarding the gradual fixing of the issues in the case, since, well, there is no legal wrongdoing, given that Article 788.3 of Alicrim precisely provides that, once the trial is over, the parties may now state whether they maintain or modify their conclusions, which can only be done once the evidence has been presented and so on. Therefore, it is not frozen in the provisional document since, as its name indicates, it is provisional, right? Not final. Excuse me. No new facts have really been introduced here. The factual basis remains the same, since both the creation, filing, assignment, maintenance, and modification of the position under investigation and the responsibilities derived from it remain within the factual account. What is being done right now is a legal assessment of these facts, and well, given the provisional nature of these legal characterizations, that allows them to be modified, right? There is also no prejudice to the defense, since the defense has been aware from the beginning of both the facts they are being accused of. They have been questioned, they have had the opportunity to challenge the evidence, and of course they have been able to argue whatever they considered appropriate as the law provides. In any case, if any defense believes it needs to formulate a response, the law itself provides for the procedure in Article 788.4 also of the Criminal Procedure Law, allowing them to request a postponement. What is not acceptable is to try to prevent the prosecution from presenting these final submissions, which is also a right that this party has. Therefore, we oppose the defense's request and ask that the position of this prosecution be deemed properly stated. To conclude, Your Honor, thank you for your patience. To point out that the case law, specifically the rulings of the Supreme Court, 172/2025 from February 27, as well as 192/2020 from February 20, and 631/2019 from December 18, supports our position against the one advanced by the other side. Thank you.
Counsel, you have the floor. With your permission, let me clarify, Your Honor, we also have the right to a defense. That is to say, the criminal procedure law allows for the modification we are seeking. The right to effective judicial protection applies to both parties in the process, not just to the defense. Of course, here two different things have been raised, I think a bit confusingly and perhaps a bit hastily. First, they are asking for the rejection of the written submissions we have filed. There is no reason to reject these written submissions, and then they are requesting an extension. I have no objection to granting an extension. I'm doing great in Badajoz, and I have plenty of work outside of Badajoz, but maybe it's time to consider opening an office here as well. What they've actually proposed to us is up to 10 days. Well, there are quite a few days between now and the date when the final hearing is expected to take place. So, as far as the deadline goes, we have no objection. What happens is that Article 788.5, which is the one that has been invoked, actually presents an even bigger problem that those who requested this extension may not have noticed. And if granted, this period is so they can properly prepare their submissions and present evidence in their defense, that is, new evidence. After this new evidence is presented, which the defense may request, the prosecuting parties can then modify their final submissions. With this, we would be in an endless cycle of evidence and counter-evidence and changes to the parties' submissions. I don't know if this should also be considered when making a decision on this matter. But, of course, if what they want is more time, well, Thursday, Friday, Saturday, Sunday, Monday, anyway, that's a lot of days. There hasn't been any substantial modification at all. Of course, there hasn't been any factual modification. As we suspected, indeed, what could happen, well, in our written submission, which couldn't be read in full, but it's there submitted and the defense parties have it, we expressly state that, regarding the facts, minor modifications have been introduced in order to facilitate the court's work in identifying the events that support the account. Identification of events means nothing more than this, that the events described in the text were already part of the case, and therefore these are not new facts. Absolutely nothing has been changed. No fact has been introduced that was not already in the proceedings. The work of the court has been made easier when it comes to identifying the events in the case that support the evidentiary account. And as for the legal classification, it is clearly authorized by Article 788, 788.4 and 5 of the Criminal Procedure Law. I'll quote from our prepared written statement for this hearing on page 23. It is Supreme Court jurisprudence that specifically supports, in line with what my distinguished colleague has mentioned, the issue of the progressive crystallization of the subject matter of the proceedings. Rulings 1143/2011 from October 28, 651/2009 from June 9 and 777/2009 from June 24. The provisional conclusions. What was the last one? 651/2009 from June 9 and 777/2009 from June 24. The process is one of progressive crystallization. This is classic doctrine of the Supreme Court. The provisional submissions define the issues to be debated at trial, but it is the final submissions that set the boundaries of the case, both in its objective and subjective dimensions. And it is precisely these final submissions, made once the evidence has been heard at trial, that must serve as the reference point to determine the unavoidable correlation between the charges and the judgment, an essential requirement of the accusatory principle. This is cited also by Judgment 10.010/2025 dated December 10. The limits to the modification of conclusions arising from defense rights apply to the facts, not to the legal classification. In the words of the Honorable Chamber of the Supreme Court, the modification of conclusions cannot in principle change the subject matter of the proceedings by substituting one set of facts for another from a factual standpoint. I insist that we have not done this. But those non-substantial factual elements, do case law does allow changes to non-substantial factual elements or their legal assessment? Supreme Court Judgment 215/2023 of March 23. And finally, a detail that we might have missed. Notice that it is indeed possible to modify the conclusions, since the criminal procedure law itself, in Article 733, allows the court to propose to the parties that they modify the conclusions if the situation arises, which has not happened. For all these reasons, of course, it is not appropriate to declare inadmissible as requested the filing we submitted. And if they feel their defense rights are compromised, we have no problem extending our stay in Badajoz for as long as the court considers appropriate. Thank you very much.
We will now suspend the hearing to deliberate. My colleague says we have 15 minutes or as long as needed. Thank you. The session, once again, of Procedure 51/2025, Provincial Court of Badajoz, Section 1. The court has decided the following. There is no substantial modification of the facts by any of the prosecution parties. There is no major change. The additions included in the final written statement submitted by the PP's defense, which are highlighted in red, contain extra factual assessments and partial evaluations regarding the evidence presented. To that end, the court has compared the charging submissions, both the provisional and the final ones. Therefore, there is no substantial modification of the facts. This is fundamental. Regarding the change in legal classification that might occur, that's true. And in accordance with the provisions of Article 788.5 of the Criminal Procedure Law, which allows the court to grant a postponement of up to 10 days, the court agrees to postpone until Monday at 9:30 in the morning. Since there can be up to 10 days, the court can choose 1, 2, 3, and so on. The court considers that until Monday at 9:30 in the morning is enough time. In any case, the parties in their final statements may argue whatever they deem appropriate regarding the homogeneity of the legal classifications. The factual changes, which we say do not exist, and regarding this matter, it will be answered again, and with a very well-reasoned response in the judgment. But this is the decision. The floor will be given to the parties exclusively for the purpose of stating or not stating their objection. Counsel for the prosecution. Do you have anything to say?
No, we abide by Your Honor's decision. No objections, we also abide.
Madam Counsel, no objections, we abide. Madam Counsel, no objection, Your Honor. No objection, Your Honor.
With your permission,
There is no...
No objection, Your Honor. We submit.
we agree with the court's decision, Your Honor.
Very well. Madam Prosecutor, you have the floor.
With your permission, Your Honor, it is understood that no... Let's see.
Come closer, come closer.
Not only is there a change in the subject of the proceedings, but there is also an assessment. New responsible parties are introduced for...
Effects of whether there is an objection or not. Okay?
Thank you. We object.
With your permission, we respectfully submit our objection. Respectfully, sir. Yes, sir.
Let it be recorded. Mr. Mendoza, wait. Come on, step up to the microphone, man.
Yes, we respectfully state our objection.
Respectfully, we state our objection. Very well. As for the objection, with your permission, we object, Your Honor. With the court's permission, let the objection be noted. We object, Your Honor. Very well. The procedure having been completed and in accordance with what has been established by this court, the session is adjourned. We will resume on Monday, June 8th at 9:30 in the morning.